I have supported the minority leader, and I got a letter from...
I think worse than that, sir, you will see millions of otherwise law-abiding citizens
tearing apart families and making our streets less safe.
Let's see what is the most compelling thing to learn from that case. How many times was this gentleman...
We are taking action. We are getting things done, and we are trying to save lives.
Today, Vice President Harris will also deliver remarks at John Lewis High School, where she will talk about...
The Ninth Circuit Court of Appeals, which has not historically been supportive of the First or Second Amendment, has chosen to support the Constitution. Ninth Circuit panel rules California's rifle purchase restrictions for 18 to 20-year-olds violate Second Amendment. Jones v. Bonta, a split panel of the Ninth Circuit, ruled that California's restriction on rifle purchases by 18 to 20-year-olds violates the Second Amendment. The case is a major victory for gun rights proponents, but that victory is likely to be short-lived. The en banc Ninth Circuit tends to reverse panels that vindicate Second Amendment claims. It's likely this case will go en banc as well. But even though its formal legal effect may be temporary, the decision is analytically, doctrinally, and jurisprudentially significant in the way it assesses state law. Those moves may be influential to other judges reviewing Second Amendment challenges, and even to the Supreme Court itself, if this case eventually makes its way to the High Court. There are actually two laws at issue in this case. The first bars young adults, those between ages 18 and 21, from purchasing long guns, rifles, shotguns, etc., without first obtaining a hunting license. That law exempts certain law enforcement and active and former military members. The second law at issue completely bars young adults from purchasing one kind of long gun, centerfire semi-auto rifles. It does not have any exceptions for hunting license holders, although it exempts the same set of law enforcement and military members. Under these laws, young adults are not prohibited from possessing long guns, including centerfire semi-auto rifles, nor barred from acquiring them in legal ways other than purchase, such as intra-family transfers, like a gift from a parent. The state's restriction on the subset of rifles was enacted in 2019 after the Poway Synagogue shooting, perpetrated by a 19-year-old with a semi-auto rifle. Only the dissent mentioned the impetus for the law. A law not challenged in the litigation, but that formed part of the panel's discussion of the overall regime, bars young adults from purchasing handguns. In the district court, the challengers lost on their claims against both the general long gun regulation and the narrower rifle restriction. That court concluded that the state won under the first step of the two-part framework. These laws did not burden conduct protected by the Second Amendment. As an alternative holding, the trial court applied intermediate scrutiny to each claim and held that the laws would pass. On appeal, Judge Ryan Nelson, joined by Judge Kenneth Lee, affirmed the ruling as to the hunting license requirement, but reversed the ruling as to the semi-auto rifle restriction. At the first stage of the two-part framework, the majority first acknowledged its limitation as jurists, not historians, and even noted that corpus linguistics could be a useful part of the historical inquiry. It had called for briefing on the question in this case, but neither party urged the court to use corpus linguistics to help resolve the dispute.
And there's been quite a few amendments. Well, the last thing to happen just happened yesterday.
In front of the view of 90 school children, directly adjacent to a public middle school.
That had you prove some type of special need in order to get a permit.
The co-chair of the Second Amendment Caucus, Mr. Massey.
It is reported from the Rules Committee. Against any resolution reported,
myself and some of the other parents responded in a way to try and get the children to safety, and thank God.
Because Bruin said that that's unconstitutional, so they drafted SB 2, which was originally introduced back in December.
The House and the Senate about pretrial detention. Well,
in determining at Step 1 whether the challenged law regulates conduct historically outside the scope of the Second Amendment, the panel stated that the framers' understanding of the Second Amendment at and around the time the ratification has special significance. It added that because the 14th Amendment incorporated the Second Amendment, our historical analysis must also consider how the right to keep and bear arms was understood in 1868 when that amendment was ratified. The court did not provide any insight into which timeframes tradition to adopt if the historical evidence was different in each period. Analyzing historical evidence and scrutiny in Second Amendment case. In the case of Jones v. Bonta, the Ninth Circuit Court of Appeals delved into the analysis of historical evidence and scrutiny in the context of a Second Amendment challenge. The court's decision, written by Judge Ryan Nelson and joined by Judge Kenneth Lee, had significant implications for understanding the historical context of the Second Amendment. and how the court applies scrutiny to gun-related regulations. The court first clarified that even though the case involved a regulation of commerce, the historical analysis focused on the general history of young adults' right to keep and bear arms, rather than specific commercial regulations. Importantly, the court affirmed that the right to keep and bear arms includes the right to purchase firearms. Therefore, laws that restrict the ability to purchase arms also burden Second Amendment rights. To assess the historical evidence, the court outlined 5 key points that supported its conclusion that the challenged law burdened the rights of young adults to keep and bear arms. These points included: 1. The deep-rooted tradition of young adults keeping and bearing arms in English law and custom. 2. The adoption of this tradition by American colonists, with colonial militias typically including all men aged 18 and older. 3. The requirement for young adults to serve in the militia and acquire and possess their own firearms during the founding era. 4. Variation in the age of majority and conduct-specific ages across different states. 5. The fact that during the Reconstruction era, most states only regulated handguns and few banned all firearm sales to minors. While the court acknowledged historical evidence supporting young adults' right to possess firearms, it did not delve into the question of whether they held rights to possess or purchase firearms without additional argument. Instead, the court emphasized that Heller had declared the right to keep and bear arms independent of militia service. Regarding counter-arguments, the court rejected California's claim that its laws resembled conditions and qualifications on the commercial sale of arms, or long-standing prohibitions on the possession of firearms saved by Heller. The court clarified that these laws burden protected conduct, making them subject to Second Amendment scrutiny. In the second part of the analysis, the court discussed the scrutiny applied to these laws. It noted that the historical analysis was limited to the first step of the framework and did not apply to the second step, which focused on the gravity of the state's interest and the degree of tailoring between the regulation and that interest. The court held that the district court correctly applied intermediate scrutiny to the hunting license regulation, but should have applied strict scrutiny to the semi-auto rifle restriction. The latter law was deemed a blanket ban for nearly all young adults, except for law enforcement and military personnel, which warranted strict scrutiny. The court emphasized that intermediate scrutiny had typically been applied to laws governing different aspects of firearms.
Involved with shooting at people?
I'm not sure in total, but
They don't care about that fundamental liberty law-abiding citizens in this country enjoy.
California knows how to do these things well, and they know how to work around things so that they can just draft this new law.
Contrast that with what Republicans did to address gun violence and crime the last time they were in charge.
And violent offender, that those folks should have no ability to be released.
If you did, you still couldn't use it because you couldn't go about your daily life without crossing through some type of sensitive location.
There's a hearing that you can't be at, your counsel can't be present, you haven't been charged with the crime.
And his teammates. All of the ancillary personnel, the moms.
Not blanket bans like the one in question. In summary, the court's decision in Jones v. Bonta provided invaluable insights into how historical evidence and scrutiny are analyzed in Second Amendment cases. It clarified the historical context of the Second Amendment and underscored the importance of scrutinizing laws that burden protected conduct under the Second Amendment. Analyzing the Jones v. Bonta decision, scrutiny, public safety, and the semi-auto rifle restriction. The Jones v. Bonta decision by the Ninth Circuit Court of Appeals brought forth several notable points in its analysis, particularly in scrutinizing the law's impact on young adults' Second Amendment rights, the characterization of restrictions as a ban, and the role of public safety in constitutional adjudication. The court's decision centered around the severe burden imposed by California's restrictions on the purchase of semi-auto rifles for young adults aged 18 to 20. It argued that even though young adults could receive these rifles as gifts from family members or obtain them through temporary loans, these measures still imposed a burden as they made young adults' Second Amendment rights conditional on the rights of others. Furthermore, the fact that the restrictions were lifted when a person turned 21 did not mitigate the severity of the burden, as any temporary deprivation of a constitutional right was considered severe. A significant aspect of the court's decision was its characterization of the restrictions as a ban on semi-auto rifles. This characterization was pivotal because it triggered the application of strict scrutiny, a higher level of judicial review. The court argued that because handguns were already banned in California and semi-auto rifles were now effectively banned for young adults, this constituted a severe restriction on their Second Amendment rights. This interpretation contrasted with the ban addressed in the landmark Heller case, where no one could possess a handgun in the home for life. The court's treatment of public safety as a government interest was somewhat equivocal. It noted that while public safety was important, it suggested that firearms were dangerous in 1791 when the Second Amendment was ratified, and the government had an interest in promoting public safety even then. However, it didn't clarify whether public safety was a legitimate government interest for enacting gun regulations. The panel's discussion of intermediate scrutiny and its emphasis on the fit requirement were noteworthy. It criticized the Ninth Circuit's cherry-picked formulation of intermediate scrutiny, which omitted the fit requirement, and argued that the fit requirement was an essential part of the intermediate scrutiny test. It cited the Oxford Dictionary of English to explain that a law is a good fit for a goal if it regulates only when it helps achieve that goal and does not burden more conduct than necessary.
Now today, as you all know as well, we're also marking National Gun Violence Awareness Day.
So in California, it was extremely difficult. California had to get rid of that good cause or just cause requirement.
Then the White House walked back that statement.
We filed formal petitions for rulemaking through the appropriate channels.
Of any semi-automatic assault weapon that was lawfully possessed before the bill became law.
Policymakers to really understand the situation that I think we are currently in.
The rule also allows certain legislation to qualify for the consensus calendar before the end of Congress.
And since most people weren't able to prove that special need,
overall, the Jones v. Bonta decision presented a complex analysis of the Second Amendment, scrutiny levels, and the characterization of restrictions as bans. It raised questions about the role of public safety in constitutional adjudication, and emphasized the importance of considering the fit requirement in the scrutiny process. Diverse opinions on the Jones v. Bonta decision. The Jones v. Bonta decision from the Ninth Circuit Court of Appeals has generated diverse opinions among the judges, highlighting the complexity of Second Amendment jurisprudence. The case involved California's restrictions on the purchase of semi-auto rifles by young adults aged 18 to 20, and the panel's ruling struck down the law, emphasizing its impact on Second Amendment rights. The majority opinion, which was authored by Judge Ryan Nelson and joined by Judge Kenneth Lee, took a hard stance on the significant burden that was imposed by the restrictions. Ryan Nelson authored the opinion. It labeled the restrictions as a ban on semi-auto guns, which opened the door to stringent scrutiny at the highest possible level of court review. Given that only a small percentage of young adults mishandled these firearms, the court argued that the statute was overly broad and employed statistical research to support its position. In addition to this, it brought attention to the lack of individualized hearings and proposed that exceptions or more individualized evaluations could be able to improve the regulation's compatibility with the interests of the government. In his concurring opinion, Judge Lee gave his support to the finding reached by the majority of the court and framed the issue as a contradiction between the law of California and the text, tradition, and history of the Second Amendment. He voiced his disapproval of a watered-down version of intermediate scrutiny and emphasized the fact that young adults are entitled to the same constitutional protections as people of a greater age. Judge Sidney Stein, a district judge from New York, who is sitting on the case by designation, wrote a dissenting judgment in which he contended that the ruling of the lower court should be upheld in its entirety. Judge Stein criticized the majority for failing to take into account important considerations, such as the disproportionately violent crimes committed by young adults or the cognitive development of these individuals. In addition, he disagreed with the categorization of the rule as a ban and questioned whether or not the freedom to purchase firearms was guaranteed by the Second Amendment. The dissenting opinion was important for a number of reasons, one of which was that it voiced criticism of historical review and the influence of the level of generality at which the analysis begins. This argument argues that historical examination in cases involving the Second Amendment might lead to varied interpretations and results, which is reflective of the current debate over the originalist understanding of constitutional rights. In contrast to certain recent opinions about the Second Amendment that have been criticized for the tone and rhetoric they use,
and it's almost like a slap in the face to the Supreme Court, just telling them, hey, we don't care what you're going to do.
Last month, while attending my oldest son's first Yaffle football practice at a public park
of 2022. Now, when it was originally introduced, it was the worst carry bill that I have ever seen.
And said he supports a ban on the sale of assault weapons, which there's no such thing.
And call on young people to continue leading efforts to end gun violence.
Tearing apart families and making our streets less safe.
Is that despite billions of revenue, the state is not funded meaningful criminal justice reform.
SB 2 was California's answer to the Bruin decision because just like New York,
the decision in Jones versus Bonta has been praised for its serious and reasoned approach to the jurisprudence surrounding the Second Amendment. The judges who were involved in the case kept a level of professionalism in their decisions, despite the fact that their interpretations of the law were not identical. In conclusion, the case highlights the continuous complication and dispute surrounding the rights guaranteed by the Second Amendment in the U.S., as well as the significance of legal interpretation and historical study in determining the outcomes of similar cases. Federal appeals court rules California's law banning firearm marketing to minors may violate the First Amendment. California's law banning the marketing of firearms to minors is probably unconstitutional under the First Amendment, a federal appellate court ruled. Writing for a unanimous three-judge panel of the U.S. Ninth Circuit Court of Appeals, Circuit Judge Kenneth K. Lee wrote that while the ban may be intended to diminish gun violence, the First Amendment demands more than good intentions and wishful thinking to warrant the government's muzzling of speech. California allows minors to use guns under adult supervision for hunting and other activities, Lee wrote, and the state cannot straitjacket the First Amendment by, on the one hand, allowing minors to possess and use firearms, and then on the other hand, banning truthful advertisements about that lawful use of firearms. The ruling reverses a lower court decision that went against several gun groups and denied their request for a pause on the law's enforcement while they sue over its legitimacy. The case has now been sent back down to the lower court for further proceedings. It marks a major victory for gun clubs that work with kids and which had argued that the ban, under Assembly Bill 2571, signed into law in 2022, prevented them from attracting young members and teaching them how to safely operate firearms. The ruling is the latest in a series of federal court decisions that have begun dismantling gun laws around the country in recent months, particularly in liberal states like California. While many of those decisions have relied on a new interpretation of the Second Amendment right to bear arms that was put in place by the U.S. Supreme Court last year, ruling hinged instead on the First Amendment. California cannot ban truthful ads about lawful firearm use among adults and minors unless it can show that such an intrusion into the First Amendment will significantly further the state's interest in curtailing unlawful and violent use of firearms by minors, and it had produced no such evidence, Lee wrote. There was no evidence in the record that a minor in California has ever unlawfully bought a gun, let alone because of an ad, or that truthful ads about lawful uses of guns, like an ad about hunting rifles in Junior Sports Mag's Junior Shooters, encourage illegal or violent gun use among minors, Lee wrote, and California cannot lean on gossamers of speculation to make such claims. Lee, appointed by President Trump, was joined in the decision by Circuit Judges N. Randy Smith, a George W. Bush appointee, and Lawrence Van Dyke, another Trump appointee. The lawsuit was brought by Junior Sports Mags and various other gun groups in California. Chuck Michel, president and general counsel for the California Rifle and Pistol Association, which was one of the litigants, praised the ruling in a statement. He blamed the ban on Governor Gavin Newsom, a Democrat. Newsom's efforts to eliminate youth shooting activities, hunting, and the next generation of Second Amendment advocates who understand their rights has been stopped again, Michel said. This is another example of legislative overreach and the politicians' willingness to trample on constitutional rights. Michel's firm, in a statement, advised gun groups to continue operating as if the ban is still in place until the lower court can act on the appellate court's decision and issue a new order on their requested injunction. California Attorney General Rob Bonta's office, which has been defending the law in court, said it was reviewing the decision and will respond appropriately. The ruling came in one of two distinct challenges to California's advertising ban. Lower court judges had denied gun groups preliminary injunctions in each. After the last of those rulings in January, Bonta had said in a statement that the idea of marketing dangerous weapons to kids is despicable, and his office would continue defending the law.
Who was harmed was the 13-year-old who brought the gun to this park.
But let's just say that you actually did get a permit under the original SB 2.
I think worse than that, sir. you will see millions of otherwise law-abiding citizens
shall not be infringed.
Take all of the guns from all of the people. That's their goal.
I have supported the minority leader, and I got a letter from...
We're California. We're just going to go ahead and ban it outright, just in a different way that's going to be harder to legislate. So,
if we are referring to the ban on assault weapons, correct. Yes.
Our children and families have endured enough fear and pain from endless gun violence tragedies. It's time to end this, Bonta said. Assemblymember Rebecca Bauer-Kayan, who sponsored the bill in Sacramento, blasted the court's decision as the work of activist judges willing to put their own agenda above the safety of our children. I am shocked and disappointed that the Ninth Circuit does not see what every Californian knows. There is a clear, substantial governmental interest in protecting our children from the scourge of gun violence that is the leading cause of death for children, she said. Erwin Chemerinsky, dean of the UC Berkeley School of Law and a First Amendment scholar, said it would be easy to cast the decision as another conservative panel ruling against guns, but the decision really wasn't about guns, but speech, and the decision was consistent with Supreme Court decisions with regard to commercial speech. Ninth Circuit rejects California's attempt to restrict Second Amendment discourse to youth. Junior Sports Mag Inc. is challenging California's law that essentially banned advertising, product placement, and any related promotion of the Second Amendment to youth. Essentially, it aimed to erase this right from an entire generation. While it didn't directly strip away the right, it prevented young people from being informed about it, creating a generational gap in knowledge about their rights. The underlying goal was to limit information and awareness about Second Amendment rights. The intention was clear. As younger individuals grew up without exposure to these rights, they would become a generation less knowledgeable about their Second Amendment rights, leading to a potential weakening of support for those rights. The Ninth Circuit Court of Appeals saw through California's intentions and expressed strong reservations about the state's actions. They emphasized that laws like AB 2751, which seek to eliminate a viewpoint from public discourse, should be subject to strict scrutiny. The Ninth Circuit made it clear that these regulations must undergo rigorous examination. In a particularly striking paragraph, a judge from the Ninth Circuit stressed that California relied on conjecture rather than facts or evidence to support its claim that speech restrictions would significantly reduce illegal firearm use and gun violence among minors. The judge highlighted that the First Amendment cannot be violated through mere inference and innuendo. California's lack of substantial justification for interfering with protected speech led the Ninth Circuit to conclude that the state had not met its burden. This strong stance from the Ninth Circuit underscores the significance of protecting free speech and the right to information.
Retired law enforcement, judges, and people of that nature.
Let's see what is the most compelling thing to learn from that case. How many times was this gentleman...
So while everybody's distracted with New Mexico's ban on open and concealed carry,
we are taking action. We are getting things done, and we are trying to save lives.
Today, Vice President Harris will also deliver remarks at John Lewis High School, where she will talk about...
For the Biden administration, about these issues we are discussing today prior...
I treated those gunshot and stab wounds at the scene while we waited for first responders.
Even in the context of the Second Amendment, it serves as a reminder of the importance of upholding constitutional rights and resisting attempts to restrict or suppress them, especially when aimed at younger generations. Ninth Circuit Court of Appeals reverses District Court's decision in Junior Sports Mag case. Junior Sports Mag filed a petition for an injunction to prevent the new law from going into effect in California. At first, the judge in the district court refused to issue the injunction, indicating that they didn't believe Junior Sports Mag had a fair chance of winning based on the merits of their case. Junior Sports Mag was unhappy with this ruling and decided to file an appeal with the Ninth Circuit Court of Appeals in the hopes of obtaining a more favorable conclusion. The Ninth Circuit Court of Appeals reversed the lower court's decision in a major way, making it abundantly evident that the judge in the lower court had not only erred, but done so in a significant way. They overturned the decision made by the district court and remanded the case back to the district court along with certain specific instructions. The Ninth Circuit Court of Appeals held that there was a high possibility that Junior Sports Mag would prevail on the merits of the case, and it ordered the district court to grant the injunction. This new development is very important moving forward. Even while concerns related to the First Amendment are at the center of this case, the repercussions of its reach far beyond the realm of the right to free expression. It is clear that California tried to control public debate and restrict free expression under the First Amendment in order to reduce public knowledge of a certain constitutional right. The Ninth Circuit acknowledged this fact and made it abundantly plain that actions of this nature to intimidate the general population and limit their right to free speech are not permissible. California's actions in this case serve as a cautionary tale, illustrating how far some states are willing to go to influence public opinion and suppress awareness of constitutional rights.
Over the past several years, and we'll continue to introduce it. I think following the federal system.
Yesterday, Speaker Pelosi, speaking at an anti-gun rally in San Francisco, stated,
I have a general idea of what I would have said under that circumstance, but no, I don't.
There's simply no rational basis for it in terms of thinking about self-protection.
Democrats actually passed the Safer Communities Act.
For years, the Democrats told us we're not coming for your guns.
For any number of criminal penalty enhancements.
This decision sets a precedent that may deter other states from pursuing similar courses of action in the future. It underscores the importance of protecting free speech and ensuring that public discourse remains open and informed. That's all for this video, folks. We'll see you next time.